couple real fascinating legal cases in the news right now, and we're going to break down a few of the specific issues attached to them right now. And joining us to help us out with that, our legal expert, former federal prosecutor, Doug Burns. Doug, let's talk first about the Zimmerman case here. As we all know, we saw, I think, almost all of us, what transpired last week, where we got not only an apology in the Trayvon trial, George Zimmerman. Take a listen to what he had to say yesterday. Also, when he's released on bail, shocking after the bail hearing, which featured not only that apology. Take a listen.
I wanted to say I am sorry for the loss of your son.
I said it last week, but also we got, in addition to the apology, a surprising admission from the chief investigator.
Do you know who started the fight?
Do I know?
Right.
No.
Do you have any evidence that supports who may have started the fight?
No.
Okay, with that, we also got this, a photograph given to investigators appearing to show the bloody back of George Zimmerman's head. This taken just moments after Zimmerman had shot Martin, as we know, fatally. It seems to support Zimmerman's claim, at least, that he was locked in, as he said, more of a struggle. He claims life and death with Martin that night than some of the original video that we saw would have suggested. So, question is making a case against Zimmerman going to be harder maybe than some of us thought at the beginning of last week?
Well, you know what was interesting? When the affidavit came out, okay, no less a figure than Alan Dershowitz, Harvard law professor, came right out swinging, saying, wait a minute, this thing is incredibly thin, was the term he used. You know, so I obviously read it quickly. And what was revealing about it was they basically left out the details of the fact that there was a struggle. And they tried to sort of make it vanilla generic and just say, he encountered him and he killed him, you know, have a nice day. And that was crazy. And I think that telegraphed a lot to the judge, okay? Because when you talk about a bail hearing, everybody, you know, throws around the term risk of flight, which is correct. Mm-hmm. But detaining somebody before a trial not only assures their presence, but remember, it also amounts to pre-conviction punishment. So you got to be careful, and you also have to make sure that the case is strong. Interestingly enough, with the caveat that I'm not a Florida lawyer, but I did a little studying, and I talked to a number of experts down there. They have what's called this Arthur hearing. Mm-hmm. And under Florida law, you are mandatorily entitled to bail unless the state can prove it by a preponderance higher than beyond a reasonable doubt. So there was no question that he was getting bail. The only question was the amount.
You know, to me, what surprised me, though, and this is more of the layman's perspective, sure. I put a lot more stock into that phone call to 911 than seemingly some of the other legal experts do. To me, cops told him, stay out of it. Yep. And for me, at that point, if I was sitting on a jury, I'd be going into this saying, well, if they told the guy to stay out of it, and all the kid had was Skittles and a juice in his pockets, whatever followed after the moment where he was told to stay out of it, since he's the one who pulled the trigger, that's on him. So I know they stand their ground, and I know that there's a debate as to how the actual encounter ensued in the sequence of events, but nobody debates the cops told the guy, we're on our way, stay out of it, it's not your job. And he still put himself in a situation 100 yards from the front door of the kid that the kid found himself later dead in.
That's an excellent point, but there's a tricky answer, which is more of a law school classroom thing, but it translates into the case, and that is that you look at the encounter separately, and was he confronted with what he perceived, and then you get into a distinction between subjectively in his own mind versus the average reasonable person. That's another, you know, to be extreme deadly force. My position, honestly, and I don't want to, you know, make it too controversial, is it seems unlikely that he was confronted with potential lethal force. Mm-hmm. And I think that was the point you were inherently making, and I agree with you.
Before I get to the Edwards case, second thing for me is, it looks like you got the Keystone Cops there in Sanford, Florida. Right. And for what they didn't do that night, what they didn't ask that night, what they didn't test that night, and now we hear the testimony where they can't give a clear answer who was or wasn't the aggressor. How much does their ineptitude, my words here, screw up the prosecution's case this time around?
Oh, I think it will, to some extent. I mean, you know, the case basically is a self-defense case. And you can have just a law school classroom discussion. What's self-defense? Self-defense is responding with, and here's the key word, commensurate force to that which you've been presented. So if you, you know, a little joke, threaten me with that pen there, I can't kill you, but I might be able to pull my pen out and stab you with the pen, you know what I mean? And the point is it commensurate to shoot a young man who has a bag of Skittles? That's going to be the issue.
Sounds like you think he's going to be acquitted.
I think it's going to be a hard prosecution
murder in
case.
second degree. I know they
Andrew,
can
I
come
think
down to
it's
manslaughter.
gonna be a
but-
hard prosecution
All right,
case.
let's talk about the Edwards day in court. And not only we were going to have a debate about this regardless of what happened, but preceding it, it got underway with some extremely strange twists and turns. We all know the story by now. Former Democratic presidential hopeful John Edwards. Well, when he arrived at court in Greensboro, North Carolina, the prosecution making the case alleging that he illegally used campaign cash to cover up that extramarital affair, and now we know child out of wedlock. The star witness, one-time aide, confidant, the guy who even took the baby's, claimed the baby that was his, Andrew Young, who then went on a vendetta against Mr. Edwards. Well, it turned out that not only did he himself have other affairs related to this, but he also was reaching out to other jurors. Before we even start, would this have been better served just having Edwards write a nice big check here and pay a fine? Or should there have been a day at a lot of legal expense here? Are the people better served by bringing this thing to court? You are a former federal prosecutor.
Of course. The answer to your question is, as a former federal prosecutor, I read the indictment really carefully, and I gave it my own litmus test, and I said, man, this thing's weak.
Right.
And the reason I said it was weak is because the core distinction and the core issue is, did a wealthy friend give him a gift, okay, or was it a political contribution? Here and there, and it's not clear. That's number one. Number two, and I'm delighted to be sitting among political experts, because politics is so related to a case like this, is you also have a Bill Clinton factor lurking in the rafters. This is a private matter, private conduct, etc. So to answer your question, yeah, I think it would have been better served not to have a full-blown, this is where we get the cliche, making a federal case out of it, right?
Very nice. And Mr. Young here, by deciding to reach out to potential witnesses, 3 of them beforehand. I mean,
I wanted
what
to address
happens now?
that because, man, I almost fell out of my chair this morning when I read a couple of articles. And they said, no, the guy, I mean, I've sat in courtrooms, okay, and a witness is on the stand, and, of course, the prosecutor says, when was the last time you talked to him? It's like, last night. And I'm like, well, at least probably maybe it was just talking about playing golf. And what did you speak about? The case. I mean, so the point you're making, and you're right, is this guy actually contacted a couple of witnesses, hold on, to talk about what they were going to say in court. It's you can't do that.
There's not any sympathetic figures in this case here, but as usual, as you said, they're making a federal case out of it. I can think of maybe a few better ways to spend the money. Hey, thanks for swinging in. I appreciate it.
My pleasure. Thank you.